Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner David Nachman. David, welcome.
Thanks so much, Michael. Always a pleasure to be here.
Now quickly let's talk about questions that usually come to us from our viewers and clients. Let's talk about those questions and give to them correct information about those issues which are kind of confusing to some of our viewers.
Sure.
One of the questions people ask all the time, I am a US citizen and I want to file a petition for my father and mother. Now, I have two brothers and sisters that are under 21, and I want to include that in the petition. So when my father or mother come, they can also get the green card and come in with them, the parents. And there's some confusion. Why this confusion is there? Because when this citizen guy filed a petition for his brother, the brother came, same petition. Brother came, brother's wife came, brother's children come. So that should be any petition that you file, children are included. What says David?
Well, when you file the case of the parents, it's pretty straightforward because what happens is that they're considered to be immediate relatives. So when you file the I-130, then that's all taken care of. The question is, where are they located? They're in India or they're in the United States?
The point here is that in the differences, let me explain. Immediate relative petitions, children or nobody can be included. Even if you have two parents that you are filing, you have to file two separate petitions,
That's right.
One for the father, one for the mother. No children are included. But you want to file your for brother or sister, you can file it, but they will go into the brother-sister categories, awaiting
family fourth preference.
In other words, the bottom line is they cannot come, and the difference is that it's a category called immediate relatives, which is a non-quota. Rest of the categories, families, are quota-based. Under the quota-based categories, the first preference, second preference, third preference, fourth preference, they are family preferences which have quotas. Those categories, the derivatives can be included. In other words, you want to file a petition for your married son or married daughter. Then it's only one petition that will cover your son or daughter for whom you are filing, the spouse and the children under 21. In all those categories, but the law was made, I don't know, hopefully, I think in the Comprehensive Immigration Reform Bill, that question came up. Why shouldn't the children also be included in the IR petitions? So that
it's a family unity.
It's a family
issue.
unity.
Right.
But right now we are talking about the present law. Under the present law, that is the reason that other categories, only one petition you file that includes your son and daughter, the wife and the children and everybody.
Right.
That's why they get confused. I did for 2 times already, 3 times in different cases. What are you saying?
Right, right. I think that you hit the nail on the head, Michael. I think that the answer is that they're just not considered derivative.
That is correct.
That's what it is. And people get confused because they're so used to the derivative analysis that they think that they are derivative when in fact they're not. Yeah.
The other question comes also, re-entry permit. Now, when a person gets a green card, that he's required to come back within 1 year. I mean, I generally tell them that you come back within 6 months because that's a separate rule. But the maximum period that they must return back is 1 year. If they stay beyond 1 year, then the question comes in, and this is a question almost every time comes in, my father went 2 years ago, can he come now? Or what is the process? And somebody have come to know about the re-entry permit. They say, okay, I understand. Why don't you file a re-entry permit for my father or mother who has the green card? And my answer to that is, and they will make an additional comment on that, is that there are two ways to look at that. If the person who went back to his home country in India, for example, and more than 1 year took place, so there was some few months more because he got sick, because there were unavoidable circumstances that he could not return back to US within 1 year. There's a visa called SB1, which is the returning resident visa. Person can go and apply at the American consul, give them the documents, satisfy the consul that there were unavoidable circumstances, then the consul can process and issue a new immigrant returning resident visa. So that's one way. But that we see very limited cases. Most of the people 3 years ago, 4 years ago, there's no unavoidable circumstances. In those cases, people ask for a re-entry permit. And the re-entry permit cannot be filed while you are abroad. Person has to come back to US, file a I-130 petition, so he's running out within a 1 year. If he already crossed one year, then it's too late anyway. But if it is 7-8 months, he still has 2-3 months to come. Let him come in, apply for a re-entry permit, and then he can go back if he wants for a few. Now, why the 6-month rule is that the 6 month he has been out, less than 6 months. Generally, CBP people will not create a problem because the burden of proof then is upon the government to prove that he has been maintaining permanent resident status. But if he is coming after 6 months, the burden of proof shifts to the applicant. So for that reason, we say to avoid that kind of problem, it's a good idea to come back within 6 months at the green card, to maintain his green card and permanent resident status. And the third thing I want to say, the last thing is, if nothing is working, if this case is based upon an IR petition, this person's son or daughter is a US citizen, forget all this SB1, forget the re-entry permit then in those difficult situations. Just file a new I-130 petition and your father or mother can come back within about year and a half. So this is a good advice in my opinion for people who have remained outside of the US for more than 1 year or plan to remain for more than 1 year. You have any suggestions?
Well, just in furtherance to what you're saying, Michael, we get the calls all the time about individuals who want to maintain their lawful permanent residence, and oftentimes the businesses that they work for in the United States may be posting them abroad. So I absolutely agree with you. If an individual is making an entry within 6 months, it's never a problem if they continue to make those entries within 6 months. Once you go between 6 months to 1 year, there is a presumption that arises. However, I can say from a practice standpoint that generally speaking, we don't see any problems with the individuals being readmitted. Very seldom when you're going between 6 months to a year. However, if you're doing it frequently,
Yes.
then there could potentially be an issue. And usually that issue comes up at the port of entry where an individual is seeking entry to the U.S. They go to the CBP officer, and the CBP officer would question whether or not they have adequate ties to the United States. Right. And usually what we'll do is if we're able to plan in advance, which we always try to recommend to our clients, plan in advance. So what we'll do is we'll have them do the things that they need to do to ensure that they can prove that they have not relinquish their lawful permanent resident status. So what are those things? One is that they have property in the United States. 2 is that they're receiving mail in the United States. 3 is that they're filing their tax returns. 4 is that they have ties to the community. What could those ties be? Could be that they are attending a local church or temple. Could be that they are members of Boy Scouts, Girl Scouts, or their children are. So all of these things can be aggregated in advance so that they're able to prove that they haven't relinquished their lawful permanent residence. And I think that one of the most important things, of course, is to have mail being addressed to you at an address in the United States, and that shows that you haven't relinquished lawful permanent resident status. Now, once you go beyond that 12 months into 1 year, there's a presumption by the government that you've relinquished your lawful permanent resident status, and then it's highly likely if you don't have a reentry permit. And Michael, I'm glad you pointed out the reentry permit. What is a reentry permit? Well, a reentry permit is a declaration of an intention to return to the United States. So what it is
to resume your permanent resident status.
Exactly.
So that's what they look into that.
Right. It's an affirmative. It's an affirmative.
But even remember we were talking earlier in the car when we were there that even I had situations with a reentry permit also. But when the officer went to the background, which generally don't do with a re-entry permit, to see this person has never stayed in the US. First time when he came with the green card, he left after 1 month. He had been just coming back and forth 2-3 weeks every year within 6 months or over 6 months. And then they say, remember, even your re-entry permit does not have the right to enter the US because we see clearly here that you have never established a residence from day one. You are not coming back to resume your permanent resident status. This permission was only given to you that you can remain outside the state for more than 1 year. But that doesn't relieve you from the responsibility of proving that you have been maintaining permanent residence in the United States.
That's right.
So that's why it's very, very important to plan it right. And as you said, I give the same advice to those people. Some people have a wrong impression that green card is just like a driving license, that every year you have to come and renew it. That's not the case. What is a green card? It's basically an evidence of your being a permanent resident.
Right.
But maintaining a permanent resident is a whole different ball game.
That's right. A lot of people don't realize once you have the green card, you can lose it.
That's correct.
That's right.
That's
it's
correct.
not. It's not like citizenship where it's very difficult to lose.
Yes.
Which brings me to a really important point that I think you were going to get to, Michael. Is how does that being outside 1 year impact your naturalization?
Yeah. But not only 1 year. Again, we are talking about the 6-month rule. When you are applying for citizenship, you have certain requirements to meet. That you have been here for more than 5 years or 3 years. If you are married to a U.S. citizen, you got green card on that basis.
Right.
The requirement of the knowledge of English language, a good moral character.
Civics.
And one of the things that people do not realize when they apply for citizenship, they total up the 5-year period and they have to show the 50% of this which is there. So they say everything is okay. What's the problem? Problem comes in when they go for the interview. Officers say, I see here that on 2 occasions you stayed each time for more than 6 months. Now, if you stay for more than 6 months, there is a presumption that you abandoned your permanent residence in the US, and that is a reason for denial of your citizenship application. But there are cases where the person stayed more than 6 months. He was in a hospital. There were unavoidable circumstances. He's a student. The students are studying, so they generally are pretty much lenient about that.
Right.
So to be on the safe side, it is a very good idea that you must not be outside of the US for more than 6 months. That is the best advice.
Exactly.
So this is not only about your entry, it also relates to your application for citizenship.
Exactly. Exactly. Critical. Very important. Yeah. And I think that at this point also it's important for us to remind our viewers that there is a new N400 naturalization form. They should be aware of it. It's increased the number of pages double. It's now about 20 pages long. But this is a new recent development.
And the last word very quickly is that some people that have tired of maintaining the permanent resident status want to give up with the green card. There's a possibility that you can surrender your green card and get a 10-year multiple visa to come back and forth.
Come back to the United States.
Running
exactly.
out of time. David, thank you very much for watching the program, and thank all of you for watching the program. If you have any questions, comments or suggestions, please contact us and we'll be happy to respond to your question. Thank you very much and goodbye.